Today we're going to focus on the TDS and other statutory disclosures. We've had some issues with the TDS, not yet serious enough that we've gotten in trouble, but serious enough that we could get in trouble if we don't pay attention to how to handle the TDS. So I want to cover the TDS, maybe give you a greater understanding of the TDS than you've ever had before. For a lot of you, it'll be a lot of review, but there'll be some insights. And my goal is that we serve our clients well and do not expose ourselves to liability to either our clients or to the other side of the transaction, especially when we represent sellers and we expose ourselves to liability to the buyer if we don't handle the TDS correctly. All right, welcome to today's class. Today we're going to talk about the TDS and how to deal with the TDS effectively, and we'll also touch on other statutory required disclosures. All right, as usual, any questions at all, don't hesitate to contact me either by email or telephone. Happy to help you in any way that I can. Let's jump right into today's subject matter. We're going to talk about challenges in today's market and specifically the TDS and other statutory disclosures. So, as I have said, this is a review of some of the material you know, but also a little bit of insight into some of the challenges of dealing with a TDS correctly and how to avoid getting in trouble in your transactions should you not handle the TDS the way it should. The TDS has become a little bit more front and center. There's been a good bit of legislation about it and a focus on the TDS by the legislature, by the DRE, and likewise, we should be paying particularly close attention to how we handle the TDS. So the first is, who is required to provide a TDS? In general, sellers of real property consisting of 1 to 4 dwelling units. So any real property of 4 or less units, in general, with a few exceptions, which I'll cover, the sellers are required to provide the buyer with a TDS. And of course, that's done through the real estate agents. Even if a real estate agent is not involved in a transaction, this requirement to provide a TDS still exists. For sellers of personal property, mobile or manufactured homes, a mobile home TDS is required. That's in the civil code. So not only do you provide a TDS in selling real property, but you also provide a TDS when you're selling a mobile home or manufactured home that is a personal property home, perhaps in a park. And then sellers of new construction, residential property consisting of 1 to 4 dwelling units that are not part of a subdivision. So we have a few agents that actually do a little bit of development, and they either build or cause to have build homes on their lots, and then they're selling new homes. Those new homes do require a TDS. And so be aware of that as well. If you sell a new home, if you're selling a home in a tract, it's probably not, TDS is probably not required. But if you're selling is what's sometimes called a spec built home on a lot to a buyer and you're involved in that, then a TDS is required. Now, the exemptions to a TDS, there are some, and they're somewhat misunderstood. So I'm going to go through the exemptions and then talk about who is not exempt, but often agents think they are. So let's talk first of all about the exemptions in the code. So the following transactions are exempt from the requirement that a seller provide a TDS. The sale of a new home when it's part of a subdivision containing 5 or more units and requiring a public report. So I just kind of gave you the reverse of that when there's less than 5 units, and it's not part of a subdivision, a TDS is required. But normally, if a builder is building a tract of homes, then a TDS is not going to be required for those. A court-ordered probate sale. So probate sales are exempt from a TDS. The sale of a bank by a bankruptcy trustee. Now, not the sale by someone who declared a bankruptcy. Every once in a while, agents get confused by that. If somebody declares a bankruptcy and the bankruptcy trustee is going to sell the home because the value of the home exceeds the homestead exemption, the trustee will sell the home, give the dollar amount of the homestead exemption to the person declaring the bankruptcy, and then use the balance of the proceeds to pay off the debtors after, of course, the loan is paid off, if there is a loan. That person, the bankruptcy trustee, does not do a TDS. But sometimes somebody declares a bankruptcy and the bankruptcy trustee will release the home back to the seller. Back to the homeowner. And then that homeowner is free to sell the home if they choose to, even though they're in a bankruptcy. And that homeowner would still be required to provide a TDS. The homestead exemption has been increased significantly. I think in San Diego County and probably LA County, it's not far different. It's more than $600,000 or $700,000. It went up from, I think, what used to be $140,000. So usually bankruptcy trustees are probably not going to be selling homes in most cases. Transfer by foreclosure, including a deed in lieu of foreclosure. And that is the foreclosing party, the bank, does not receive a TDS from the party being foreclosed on. This is not the same as someone selling a home they acquired through a foreclosure. So only a transfer by foreclosure. If you are the closing party, then you won't receive a TDS. Sale by a fiduciary. Now, specifically, I want to talk about a successor trustee liquidating the assets of a deceased person, provided the trustee has not lived in the property within 1 year preceding the transfer of title. So typically what you'll have is a successor trustee. Mom and dad had the home in a trust. Dad passed away a few years ago. Mom now just recently passed away. And the successor trustee is now liquidating the home for the benefit of all the beneficiaries, the children who are heirs to the property. That trustee, if they lived in the home within the past year, would be required to do a TDS. But if they did not or do not live in the home, the successor trustee is exempt from providing a TDS. The sale by a trustee administrating the assets of a beneficiary under a guardianship or a conservatorship or a trust, provided the trustee has not lived in the property within 1 year, just the same with a successor trustee, and the trust is not a revocable trust. If it's a revocable trust in general, they are not exempt from a TDS. But sometimes a trust is created to take care of a minor, or even someone who's not a minor but doesn't have the capacity to take care of themselves. And that trustee, if they sold the property, would not, assuming it's not a revocable trust and they did not live in the property within the past year, that trustee would not be required to provide a TDS. If you have a question about that, give me a call and I can review it with you. It's why it's important. One of the many reasons it's important to get a copy of the trust so you can understand exactly who all the players are and then whether or not the trustee might have to provide a TDS. In general, revocable trusts where the trustee is a former owner or lived in the property within 1 year, either one of those, are not exempt from providing a TDS. So typically, if someone puts their property into a trust usually for tax benefits and other, to protect their asset, perhaps from any liability they might have to somebody who sues them, that revocable trustee would still be required to provide a TDS. Transfer from one co-owner to another co-owner, a TDS is not required. Transfer to a spouse, child, grandchild, parent, or grandparent, that transfer does not require a TDS. We're not usually involved in these types of transactions. Transfer between spouses as part of a divorce proceeding does not require a TDS. And of course, a transfer to any or from any government entity does not require a TDS. So 7 through 10 do not usually involve a real estate agent. But if you are involved in such a transfer, your client would not be required to provide a TDS. Now, who is not exempt from providing a TDS? In other words, these folks do have to provide a TDS, but often agents mistakenly believe they're exempt. I get calls, I get emails all the time. Well, they're such and such, so they don't have to provide a TDS. Oh, no, yes, they do. So let me review a short list of those. In general, the following sellers are not exempt from providing a TDS. In other words, they must provide a TDS. Landlords of rental property, in general, they provide TDSs. The fact that it's a rental property and tenant occupied does not exempt the owner from providing a TDS. I get this call frequently. Sellers who've never seen the property, believe it or not, I've actually had agents say to me, well, they can't do a TDS. They've never seen the property, so obviously they're exempt. No, that's not true. Just because they've not seen the property doesn't mean they're exempt. Absentee owners, of course, they are not necessarily exempt. Trustees of revocable trusts, I've covered that already, so that should be pretty clear by now. They are probably not exempt from providing a TDS in almost every case. In general, the sellers of a property acquired by a trustee's sale. Now, this comes up from time to time. Somebody buys a property as a result of a foreclosing party having foreclosed on the property and now selling it for example, a trustee's sale, or a bank selling it even after they've acquired the property. Well, I acquired it as a result of a foreclosure. Well, you're not exempt unless you were, in fact, the foreclosing entity. Then you don't provide a TDS when you sell it. But if you bought it from a foreclosing entity, in other words, you bought it from the bank at a trustee or sale, or you bought it as an REO property, when you sell it, even though you don't know any history about the property, you'd still have to provide a TDS. You'd have some history due to your ownership of the property. Flippers, every once in a while somebody will tell me, well, I'm a flipper, so I'm exempt. No, that's not true at all. And then finally, this is also a common misconception, relo sellers. So a relocation company acquires the title to the property, as a part of their arrangement with the corporate entity that they are contracted with, and they ended up buying the property from the quote seller, and now they're selling it. They are not exempt from providing a TDS. In those cases, the original seller should be providing disclosures and TDSs to the relo company, and then the relo company passing them on to the ultimate buyer. All right. Now, when should a TDS be provided to the buyer? Now, this is where we can get into quite a bit of trouble. This is the timing of some of these things can be very, very important and can have some significant consequences if we don't observe the timing. So by law, The law says as soon as practicable before the transfer of title. So, if a FSBO is selling their property, one could argue just as soon as the buyer's offer is accepted, it's practicable for the FSBO to provide the TDS and not wait until a few days before the close of escrow. That might be a little late. And just like an agent-involved transaction, there could be problems with a so-called late delivery of a TDS. But the law doesn't specify exactly when. Not so with the RPA. The RPA specifically states that the TDS must be provided within 7 days of acceptance. That's the boilerplate, unless it's modified. So you are in default of the RPA if you do not provide the TDS in a timely manner. And I'm going to review some other consequences that you could suffer or your client could suffer if you're the listing agent for not providing the RPA within 7 days of acceptance. Now, the buyer has a 3 to 5 day right of rescission after the TDS is delivered. So not delivering the TDS in a timely fashion could be problematic. That right of rescission cannot be waived. I don't think I have a slide that occurs to me now as I'm speaking to you. The importance of providing a TDS, and for that matter, all disclosures prior to the buyer having the property inspected by a physical inspector. A buyer should review the TDS and all other disclosures, especially the SPQ, with the physical inspector at the inspection to get answers to any issues raised by the TDS or SPQ. And so failure of the listing agent and the seller to providing those disclosures in a timely fashion could set the seller and the agent up for some liability later because the buyer would claim that they did not have an opportunity to review the TDS with their inspector. That has some merit, that complaint that the buyer could lodge. And I've actually been involved in mediations where that issue has come up, that the TDS or SPQ was delivered after the physical inspection. So as a listing agent, you want to get them out quickly, and you want to encourage the buyer's agent to schedule their inspection just as soon as they've received your disclosures. As a buyer's agent, if you're going to be doing the physical inspection before you receive disclosures, number one, you should make an attempt to get the disclosures before the inspection. And number two, point out to the buyer that there's a certain risk to going ahead with the inspection without the benefit of disclosures, because you will not have the opportunity to review the contents of those disclosures and any questions you have as a result of those disclosures with the physical inspector. So again, that 7 days is the maximum time in the contract. And I would argue it's a pretty good idea to get them out within the first 2 or 3 days, and as much as possible before the buyer does their physical inspection. In order for a seller to avoid this right of rescission by the buyer must receive the TDS before the buyer prepares their offer. Prepares, the code actually specifies signing the offer. So the buyer has an absolute right of rescission if they receive the TDS after they've signed their offer. And that's a 3-day if it's delivered in person, 5-day if delivered by mail or email. Putting the TDS in the MLS will not meet this requirement. Some agents believe that by posting the TDS in the MLS, that's delivery to the buyer. That is not delivery to the buyer, because you cannot document the buyer's actual receipt of the TDS. The buyer does not have direct access to the TDS. It would require the buyer's agent to provide the TDS to the buyer, and you don't have any assurance that that has been done. Have the buyer return a signed copy of the TDS with their offer if you want the TDS to be delivered prior to accepting an offer, and so that you can avoid the right of rescission. The reason I talk about that now is we have very, very short escrow and contingency periods on some of our offers. I think I spoke about it in a recent webinar where instead of having the buyer waive all their contingencies immediately with the offer, it might be a good practice to give the buyer 5 days to do their inspections and then remove contingencies, because you're going to be providing the TDS immediately, and the buyer has those 5 days anyway. So it makes for a much smarter and liability proof or liability minimizing your liability by providing a window of time to do investigations and to review the TDS, because the buyer has that right anyway. Now, liabilities to a seller and an agent when the TDS is delivered late or not at all. And this is, I want to stress this because in some cases, we have agents being a little lax. Maybe not you, not anybody on this call, but you might know an agent who's a little lax in getting that TDS out right away. And that can be extremely problematic if there ever is a claim. Now, no harm, no foul, but you shouldn't be running your career that way. When there is a claim, that is something that is going to get looked at. When was the TDS delivered? And like I said, I've actually been in mediation where there was some consternation by our defense counsel, we had the seller, as to whether or not the buyer received the TDS prior to the buyer doing their physical inspection, because that could be problematic in a lawsuit. So if you deliver the TDS late, you're simply extending the buyer's right of rescission. They have an absolute right of rescission. There's a famous to me anyway. I read lawsuits from time to time. There's a lawsuit which I think is very interesting about the problem of a late delivery of a TDS. It's Richmond versus Hartley. Richmond's the seller, Hartley's the buyer. Now listen to this. Richmond and Hartley entered into a contract that called for the close of escrow to be 2 years later. That's perfectly legal, and that was the way the contract was set up. So they had a 2-year escrow, if you will. During that period of time, the buyer, Hartley, actually managed the property. It was a mixed-use property. It had rental unit, a couple of rental units, as well as a residence on the property. So a TDS was required. It wasn't exempt, and it was a 2-year escrow. And Hartley, the buyer, was managing the property. Very familiar with the property, one would argue. The day before escrow closed, the buyer elected to cancel and got away with it. Why? He'd removed all his contingencies, performed all his investigations, but he had never received a TDS. So he got an attorney. Attorney understood the code, and the Hartley canceled the night before it closed. Of course, the seller sued the buyer. You can't cancel. The court, including the appellate court, said absolutely the buyer could. The right of rescission is an absolute right. And because the TDS was not delivered in that case at all, a 2-year escrow went down the tubes. And the seller was not able to defend himself against the buyer's right to rescind. A potential for future claims by the buyer. There's a misconception agent sometimes has, and that is when a buyer closes, they accept any disclosures the buyer received. Well, maybe yes, maybe no. There is another famous lawsuit. I don't have the parties. I remember the lawsuit quite well. I've talked about it before. And that lawsuit involved a buyer of what you might call a high-end property in the Bay Area in San Francisco. It was alleged that the property was designed by the same architect who designed the Hearst Castle. She's was a famous architect and designed many residences in the Bay Area. So you can only imagine an architect who designed the Hearst Castle and designed other high-end properties. That added a certain value to the property. So it was alleged by the seller that this property and the listing agent, that this property was designed by that architect. Before escrow closed, the seller and the listing agent became concerned because they didn't have any proof that it was designed by the architect. They were told that it was when they acquired the property. The seller was told. So they, about a week before close of escrow, disclosed that the property may not have been designed by the architect and encouraged the buyer to investigate for themselves whether or not the property was designed by the architect. The seller actually stated they had no proof that it was. It was their belief that it was. Now, here's the key. That was done not 3 weeks before escrow closed, not during the contingency or the seller's disclosure period, those 7 days. It was done just before escrow closed, a week before, but still pretty close to the close of escrow. The buyer actually did go out and seek experts. Got one expert to say it probably was not designed by the architect, actually found that out before close of escrow. Got another expert that said it probably was. So the buyer didn't know. The buyer closed. The buyer then was able to confirm it probably was not designed, sued the seller. And under the doctrine of mitigation of damages, was able to collect damages from the seller because they argued, I found out too late that it may not have been designed by the architect. I'd already agreed to a sale price. I'd already done other things. In this particular case, the seller sold their house and now, needed a place to live. They collected several $100,000 in damages from the seller because of a late delivery of a disclosure. So a buyer could close and successfully sue a seller and the agents involved for defects, even if disclosed in a TDS, if that TDS is delivered very late into the transaction. Again, nobody on this call, I hope, but I've been told there are some agents that even a couple of days before close of escrow have yet to deliver a TDS to a buyer. Folks, that is just a claim waiting to happen. So don't be guilty of that if you're not good for you. And if you are, I would amend that procedure immediately, because that could get you and your client in significant trouble in the future, because simply disclosing it and the buyer closing anyway doesn't necessarily protect you, especially if it was disclosed late in the transaction. Agents could be cited by the DRE and the local Association of Realtors for failure to fulfill an agent's fiduciary duty to a buyer if they represent the buyer, or certainly failure to provide a professional standard of care to a buyer, even if you do not represent the buyer. Civil code requires you to act professionally, even to your non-clients. So it would not be hard. In fact, it gets done from time to time for a plaintiff's attorney, a buyer's attorney, to allege successfully that the professional standard of care required you to provide the TDS in a timely fashion, and you didn't do it. So you're guilty of of violating that standard of care, and are therefore liable to the damages the buyer might suffer. There's just way too many liability issues for a late delivery of the TDS. What's even worse is a non-delivery of a TDS. And again, you can't make a seller provide a TDS. So if the seller has provided the TDS and you fail to deliver it, shame on you. But if the seller is willfully or negligently failing to deliver a TDS to the buyer when they're required to do so, there's number one, the seller could be liable for any damages suffered by the buyer that resulted from the seller's failure to deliver the TDS. And the buyer could cancel the purchase contract anytime before the close of escrow if they don't get a TDS and the seller's not exempt from a TDS. So a seller who's willfully or negligently not providing a TDS gives the buyer, just like that lawsuit, Richmond versus Hartley, gives the buyer an open window to cancel at any time. Okay, completion of the TDS. The TDS, I'm not telling you anything you don't know, but I want to kind of remind you of it. The TDS consists of 5 sections. Frequently, agents will think about the 4 sections, but there's actually a 5th section. I'll remind you of it. And it's pretty important, by the way. So section 1 is coordination with other disclosures, the so-called substituted disclosures section. I'm going to talk about each of these sections in a little more detail after I go through all of them. Section 2 is the seller's information section. Section 3 is the seller's agent's inspection disclosure. Section 4 is the buyer's agent's inspection disclosure. And Section 5 contains an advisory to the buyer to seek additional inspections and advice of experts about the condition of the property. And then a signature section where the parties acknowledge receiving the TDS. So let's look at those sections in detail. Section 1 has been in the news, if you will. Certainly, I've talked about it lately. Agents are becoming a little more aware of it. So I want to just remind you about Section 1. It's called the coordination with other disclosures, or the so-called substituted disclosures section. Now, when the TDS first came into effect in 1987, the legislature thought that a seller could hire an inspector to make the required disclosure on behalf of the seller. Of course, that never materialized. No inspector ever agreed to take on the liability of making disclosures on behalf of the seller. And so that was never done. And so that was originally the intent of Section 1. So since it was never done, this approach, this section rather, was generally ignored until recently. It's still being ignored by some agents to their chagrin if they get caught up in it. But we are still seeing TDSs on transactions that are closing or about to close, and Section 1's not completed. In 2018, the legislature reaffirmed the buyer's right to rescind the transaction after receiving a fully completed TDS, which included sections 1, 2, and 3 must be completed. Section 1, the substituted disclosure section. Section 2, the seller's information question, a section where the seller answers questions. And Section 3, the listing agent's visual inspection section. Now, the TDS is not considered complete unless Section 1 is completed, even if the seller had no substituted disclosures. So it was sort of a problem. The form sort of didn't allow for a seller to logically complete Section 1 if they didn't have substituted disclosures, and no seller does, and still complete the section. So Section 1 was amended, and the no substituted disclosures was added in 2019, an option where you could check. I think it's option 3 on the TDS now, in order for the seller to complete Section 1, which was required by the Civil Code. So what does that all mean? Well, what it means now is I can understand why people are not completing Section 1 in the past, but not going forward. Section 1 in general, you can check the box, no substituted disclosures, and failure to fill out Section 1 constitutes non-delivery of the TDS. Section 2 is the seller's information. The seller is required to answer all questions and provide explanations for all yes answers. That's in the Civil Code. It's also part of the RPA. It's restated in the RPA. So a TDS is not considered complete, and delivery to the buyer is not accomplished unless all questions are answered and all yes answers are explained. I've been involved in mediation. We don't get into a lot of lawsuits. That's the good news. I can count on one hand with a couple of fingers left over before we ever got into actual lawsuits being filed and arbitration occurring. Maybe lawsuits are filed, but they're generally resolved in mediation. And in mediation, sometimes when a question was not answered, the seller was held accountable, and so was the agent, because civil code required the questions to all be answered. And I tell a story often. We had a seller who did not complete a TDS later got sued over that very issue that the question he didn't answer revolved around. And when I talked to him about it, he said to me, "Walt, I'm 80 years old. What do I know about a TDS? How come your agent didn't point out to me I didn't answer that question? I didn't know." That's a good point. That potential liability to us was very real. So, pay attention to the TDSs that your clients fill out. Section 3 is the listing agent's visual inspection section, and the listing agent should attach an AVID reporting the results of the listing agent's visual inspection to the buyer. We require that at RE/MAX United and RE/MAX All Pro. We require the AVID be provided to the buyer as a part of the agent's responsibility to perform a visual inspection. Absent an AVID, the listing agent must note the results of the agent's inspection in Section 3. A TDS is not considered delivery if one of the above is not done. Sometimes agents check the box, but they don't attach the AVID. Guess what? You did not deliver the TDS. Sometimes agents don't check the box, but leave the other things blank, the blanks where they could put the results of their inspection. They have not delivered a TDS. So Section 1, 2, and 3 must be complete to deliver a TDS. Section 4 is the buyer's agent's visual inspection. And just like the listing agent section, the buyer's agent should attach an AVID reporting the results of the buyer's visual inspection to the buyer. And that's a requirement at RE/MAX United and RE/MAX All Pro. Absent an AVID, the buyer's agent must note the results of the agent's visual inspection in Section 4. Now, here's the difference, though. A buyer's agent's visual inspection is not necessary to accomplish the delivery of a TDS. So a buyer's agent does not do his AVID, even though he checks the box. Is the TDS delivered? Yes, it is, assuming Sections 1, 2, and 3 are complete. The buyer's agent has still got a problem because he's required to provide the AVID and needs to do that, but it's not part of the delivery of the TDS. Section 5 is the buyer's advisory and signature acknowledging receipt section, and the buyer's signature does not constitute an approval or documenting a review of the TDS. From time to time, I have agents call me. They're having trouble getting the TDS back from the buyer's agent. I call the buyer's agent. Well, my buyers haven't reviewed it yet. Well, that's not, I don't need them review it before they sign it. I mean, they should review it. I accept that. But signature on the TDS simply says they received it. I often use a FedEx delivery of address. I don't know why I picked dress. I don't mean to be sexist, but if FedEx delivers address to somebody, presumably a lady, but not necessarily, they don't wait until the person tries it on and decides they want it before they require a signature. They say, no, you sign for it. If you don't like it, you can send it back, but you have to sign, I gave it to you. Same with the TDS. You can still object to the TDS. You can still raise an issue and cancel, but you have to sign saying you got the TDS. So you should ensure that the buyer signature on the TDS is returned to you in a timely fashion. A buyer's signature merely documents the receipt of the TDS by the buyer. The buyer, by the way, is required to return a signed copy of the TDS to the seller by both civil code and the RPA. And failure of a buyer to do that could constitute a breach of contract. So a seller could give a buyer a notice to perform to sign the TDS. And if they don't do it after the notice to perform expires, the seller could cancel. Because the seller is entitled by code and contract to have a copy documenting that the TDS was delivered to the buyer. Okay, agents should ensure that all questions are answered and yes answers are explained before delivery of the TDS to the buyer. As I said a couple of times already, sections 1, 2, and 3 must be completed. All questions answered, all yes answers explained. Now, for buyer's agents, if you receive an incomplete TDS, you should go ahead and deliver the TDS to the buyer. You don't want to hold it up because there might be enough information that the buyer wants to act on some of the information. But also state that this is not complete and you are attempting to have it completed correctly and will forward a completed TDS to the buyer as soon as you receive it. And again, the clock isn't ticking on the buyer that 5 days until the TDS is delivered complete. Most questions ask, are you aware of? The questions are not asking the seller to make an affirmative statement. Every once in a while, people say, well, how can the seller do a TDS? He's never seen the property. He knows what he knows. That's the answer. A seller is aware of what they're aware of. They've never seen the property, but they know whether they're aware of the roof leaking or not. Or the air conditioner doesn't work. If they're not aware that the air conditioner doesn't work, the air conditioner could be rusted, solid, shut, not working at all, but the seller doesn't have a clue because he's never seen the property. He could answer that question, no, I'm not aware of it. See, so it's an awareness question, not a statement of the actual condition. Sellers should receive and review a disclosure information advisory, DIA, before completing disclosures, especially the TDS and the SPQ. We require that at RE/MAX United. I believe it's required at All Pro. I'd recommend to Kenny it should be required at All Pro because a seller should be advised by their agent, the listing agent, on how to correctly fill out disclosures. You're not telling the seller what to fill out, what to say, but you're telling the seller how to address disclosures. And failure to give that advice to a seller could open the listing agent up to liability. So when the DIA was created by Carr, I thought that was a wonderful form because up till then, I was a little concerned that listing agents were not reviewing how a seller should fill out a disclosure. Again, not what the seller should say, but what the seller should be aware of when filling out a disclosure. The DIA does an excellent job of doing that. So the DIA is required and should be provided to the seller prior to the seller completing the disclosures. In the sale of 1 to 4 residential units, including mobile homes, Civil Code requires both agents to conduct a reasonably competent and diligent visual inspection of the accessible areas of the property. Should be a quote after that. And report the results of the inspection to the buyer. We do that on an AVID. The key phrase in the code is report defects that should have been discovered during the inspection. That's important to note. Not taking your visual inspection seriously and not reporting things that you should have reported can be problematic. From time to time, I have buyers and plaintiff attorneys claiming that the buyer's agent didn't do a diligent inspection because he should have noted XYZ. She should have seen ABC. So I try to defend against that, of course. The point I want to make is make sure you're paying attention, and anything that you see or should see, you should report. At RE/MAX United, RE/MAX All Pro, as I said, we require agents to complete an AVID and attach it to the TDS, either Section 3 or Section 4. And the TDS is not complete unless the listing agent completes Section 3. Kind of a review of what I've already said. The agent's visual inspection and disclosure obligation applies even if the seller is exempt from providing a TDS. Residential 1 to 4 unit properties almost all require agent visual inspections. So, it could be a probate sale. So the seller's not required to provide a TDS, but the agents are still required to do an AVID. Okay. As an example, when reporting your observations, you should, 1, avoid quantitative adjectives. Avoid quantitative adjectives. Qualitative could be okay. Like, qualitative is a brown stain. There's nothing wrong with a qualitative, the quality of what you're observing. But there is something wrong with a quantitative, small, minor, hairline. Don't say those things. Don't make quantitative adjectives in your AVID. Avoid speculation on the cause of the defect. Brown stain due to leak. How do you know that brown stain's due to a leak? Roof leak. How do you know it's a roof leak? How do you know somebody didn't spill coffee when they were in the attic? I don't know. Could be a plumbing leak. We don't know. So avoid speculation. Do not make assumptions or determinations. The most common one is mold. Unless you've tested that black spot in the bathroom for mold, you really can't say it's mold. You can't make that determination. You're not an expert. You haven't done the test. So don't make assumptions or determinations. Just describe what you're looking at. Avoid positive statements. I see this from time to time, and I almost have a heart attack when I see it. Property appears to be in good condition. Oh my gosh, don't make positive statements, Contrary to what your mother said, say only negative things. Don't say positive things ever on an agent's visual inspection. Do not concur with the seller statements. I see this from time to time. My heart also flutters a little bit too, tachycardia. I do not see anything to contradict the seller statements. That is a a misapplication of your obligation to inspect the property. Don't do that. Only inspect accessible areas. You don't have to go into the attic. You don't have to go under the house. You don't even have to open up cabinet doors. You don't have to look under furniture, behind furniture. You don't have to move boxes. That's not required. Do not inspect common areas or off-site inspections. So you don't need to inspect the pool area. You do not need to make comments about the neighborhood, and you should not, by the way, in your agent's visual inspection. When reporting your observations, you should avoid the phrase "nothing to note" or leave blanks. It's harder to prove, if there is litigation later, that you made the inspection or that you made a diligent effort to observe and look for defects. So it calls into question whether you've actually inspected the item. It's better to note something if possible. Even if you write the word inspected or you put a check mark, that's better. But in general, there's always something you can note about everything, every room. And the more you put down, the more likely you can demonstrate that you've inspected the property. When providing an AVID for properties with more than one unit, in other words, 2 to 4 units, you do not do an AVID for 5 units or more, but you do for 2 to 4 units. You must provide an AVID for, that's supposed to be 4, it's a typo, for each unit that the property consists of. You identify the specific unit on the AVID. Not true with a TDS. You could do multiple TDSs. I like to recommend it to sellers, but civil code does not require it. So a seller is selling a 3-unit property, they can do 1 TDS. Now, the problem is they have to answer questions and make explanations, and they have to reference what unit they're talking about. On an AVID, you do have to have 3 AVIDs if you have 3 units, 1 for unit 1, 1 for unit 2, 1 for unit 3, and each unit is inspected separately. The SPQ. The SPQ is not required by civil code. It is required by the RPA when a TDS is required. The vacant land purchase agreement also requires a VLQ. So, the SPQ or the VLQ is required in the agreements. The requirement for a seller to provide an SPQ or a VLQ could be counted out, but this is not recommended. As the seller's agent, don't counter it out. Sometimes as a buyer's agent, we don't have much choice, especially in this market. It's hard to push back on that, but the seller will counter out. I'm not providing you an SPQ. I get calls. Can they do that? Yeah, legally they can. They shouldn't, but they can. If the transaction is TDS exempt or the SPQ is countered out, the seller is contractually obligated to provide an exempt seller disclosure, an ESD. That's contained in paragraph 10A4 of the RPA. So if you are not providing an SPQ because you're exempt from providing a TDS, or the seller has said, I'm not providing a SPQ in their counter, they should still provide an exempt seller disclosure. The exempt seller disclosure provides the seller with an opportunity to make disclosures that are required by civil code. Now, the ESD is not a requirement in civil code, but those questions on the ESD, which are also the questions on the first page of the SPQ, those disclosures, if they are, if there is something to disclose, must be provided to a buyer. The 2 most common ones are a death of an occupant of the property within the last 3 years, or an insurance claim affecting the property within the last 5 years. A little side note here, a little tip, a little fringe benefit of being on the call or listening to this recording. Agents often misunderstand insurance claims in the last 5 years. They often think the seller filing an insurance claim in the last 5 years. That is not what civil code says. So if I bought a house and 3 years later I'm selling it, and I was aware that the person I bought it from a year before I bought it filed an insurance claim, do the math, that's going back 4 years. I'm still required to disclose what I know about it. Any insurance claim, not claims filed by the seller. That's a mistake agents often make. They assume that that's talking about insurance claims filed by the seller. No, that's any insurance claim affecting the property within the past 5 years that the seller's aware of. Of course, a claim that the seller made, they should be aware of, but they might also be aware of a claim that the person they bought the property, the previous seller, made when they bought the property. Okay. SPQ should be delivered within the first 7 days. We talked about that. Late delivery of an SPQ extends the buyer's contingency period, could reinstate a contingency, and could create a cancellation right for the buyer. So you don't want to deliver the SPQ late, just like you don't want to deliver the TDS late. The seller should disclose any material facts known to the seller, even if they are related to a prior owner, sort of like that insurance claim. If the seller is aware of a problem the prior owner had, the seller should disclose that. And a long period of time that has lapsed since the facts were first known doesn't excuse the seller from making disclosures. So the seller should disclose something, even if it was a problem a long time ago. The last question on the SPQ requires the seller to provide copies of the following that are in the seller's possession. This is a seller obligation. Any reports the seller has, any inspections the seller has. Hence, you should be providing the inspection report from a previous escrow or an inspection report from when you acquired the property. If the seller has it, an agent is required to provide it if it's in the last 3 years, because by code they have it. Disclosures, warranties, maintenance advice, estimates, studies, surveys, anything that pertains the condition of the property. The SBQ specifically states the seller is to attach those to the SBQ and provide them. Statutory disclosures, real quick, I'll wrap this up because they have the same rescission rights as the TDS. So I just want to stress you want to get those out in a timely fashion as well. They carry the 3 to 5 rescission right, and they cannot be waived. And the statutory disclosures are, of course, the TDS, the lead-based paint disclosure, if applicable, the natural hazard disclosure, the zone report, and finally, the fire hardening and defensible space advisory disclosure and addendum, if applicable. So the 2 and 4, you may not have to provide, you do almost, you may have to provide a TDS. You almost always have to provide a natural hazard disclosure. There are no real property transactions that are exempt from providing a natural hazard disclosure zone report. So order it early. You're going to need it so you can address the fire hardening and defensible space advisory issues. And you don't want to deliver it late because, handing a buyer a natural hazard disclosure zone report a week before escrow closes just opened up that buyer's right to walk away and get their deposit back. So get the natural hazard disclosures ordered quickly. You can order them off. In this market, you're going to sell your property in about 7 seconds anyway. So, order these when you take the listing. If required, a statutory disclosure delivered to the buyer before the buyer writes their offer. If the required statutory disclosures are delivered to the buyer before the buyer writes their offer, there is no right of rescission for these disclosures. And again, I bring that up because of the market we're in today. There is a contractual right of rescission in the RPA for all disclosures. The buyer can waive or remove the contingencies associated with those disclosures before receiving them. So we've talked about that in the past. All right, folks, that wraps it up. And so just right at an hour, let me stop my screen share and ask, do we have any questions?
Well, there's a couple questions in the chat.
Okay.
One is from Del Hickman, and he's asking, are HOA docs disclosures?
Well, they are disclosures. They're not statutorily required disclosures, but they're in the civil code. So, yes, HOA docs must be provided. They're the part of the code requires that you provide them, and the RPA requires that you provide them. So, does that answer your question, Del? I'm looking at Del.
No, not. Well, it was mainly in regard to the ability to rescind or extend the time period.
That's
it comes so late.
That's interesting, okay? Because you bring up an interesting question, and it's sort of a little bit of a nuance, but I don't want to confuse you. But you can remove your contingencies relative to HOA docs before you receive them, but you're still entitled by law to receive them. So, in fact, they're not a statutory disclosure. There's not a statutory right to cancel once you receive them. There is a right to cancel if you haven't removed your disclosures once you receive them. So, and one would argue that you should, if you are going to, as a listing agent, want all contingencies removed, you should provide them, because one could argue there was information in them that you withheld and induced the buyer to remove contingencies that he might not have removed if he had the benefit of that. So you do run the risk of not providing them. But the fact is, a buyer's agent should be careful not to remove those contingencies, HOA document contingencies, until the HOA docs are received, because legally you can do that. And you will not get an automatic right of rescission. Those 4 documents that I talked about are the only documents in civil code that carry a statutory right of rescission that cannot be waived. Does that better answer your question? Okay, great. It's a good question.
Well, Sharon Miller wants you to please give examples of substituted disclosures. Are those things like termite reports?
Well, they're not legally substituted disclosures, so you want to make sure that you don't use the term substituted disclosures. There are no substituted disclosures that exist. It was never adopted. In other words, the legislature thought that the inspection industry would step up and say, yeah, we can provide you all your disclosures for you. We'll inspect your property and answer all these questions. And it never happened. Now, and so, since it never happened, it kind of messed up the Section 1 of the TDS. Now, Section 1 does have a place where you can attach additional disclosures, like you can attach, let's say you had a termite inspection done prior to this escrow being open. You could attach it to the TDS. You're not required to do it, but you could. You could attach a previous physical inspection that you received to the TDS. You're not required to do it. So those are not substituted disclosures. Those are attachments that are possible. In general, I recommend you always check the box, no substituted disclosures, and then provide all those other reports and disclosures that you have in the course of your transaction. That's the best way. And that's actually CAR's recommendation as well. Next.
Mary Jo asks, if the buyer's agent provides an AVID with little to no items noted, does that pose any risk to the seller or to RE/MAX United or me as the listing agent?
No, I think absolutely not. You're not responsible for the buyer's agent performing poorly. So, that does not put you at risk. Just make sure your AVID is thorough. And of course, as the listing agent, you are required to deliver some sort of inspection report at RE/MAX United and All Pro. It is an AVID. The code does not require an AVID. It does require the seller to provide a report of the results of their inspection as part of the TDS. And then they put some blanks on the TDS, not nearly enough blanks to do a thorough job. So AVID is the right way to go.
That's all the questions in the chat.
Well,
very good.
I got a quick question. If you receive, if a buyer's agent receives a TDS that we deem to be incomplete, and we advise them that it's incomplete, do we still require them to sign and return that incomplete TDS?
Well, require our buyer to sign and return.
Correct.
Right. I would recommend, like I said in the presentation, if you receive an incomplete TDS, I would recommend you still forward that to the buyer, unless it's something, if you can get the completed one within the hour, well, then, why not? But often you're going to have a little bit of turbulence or take time to get it. In the meantime, the TDS you received might contain enough material information, even though it's incomplete, that the buyer might want to take some actions. So you provide it to the buyer and you tell them that, look, this is not complete. And you do that in writing in an email, and I'm going to endeavor to get a complete. You're entitled. You should use that phrase. In fact, you as the buyer are entitled to a complete TDS, which includes answers to all questions, which includes explanations of yes answers, and which includes the listing agent's visual inspection report. You could list those three things in your email to the buyer. I am providing you what I have so far. I would argue, the buyer should sign that. Why? Because the buyer's not approving it. The buyer is simply saying, I got it. And it could help you possibly in the future. Gee, if I knew this, I would have never done that. Why did you not tell me this? So sometimes I see agents arguing back and forth, and meanwhile the disclosure sits in somebody's file, and the buyer could have benefited from seeing what was on the disclosure, even though it's not complete. So I want to avoid that. So yes, do have the buyer sign it. but the buyer's not in any, the buyer hasn't acknowledged that he's got a TDS. It can't be waived. I mean, acknowledge he received a piece of paper, but if that piece of paper is not complete, Civil Code says the TDS has not been received by the buyer. The buyer's received so much, for lack of a better word, scrap paper, that he happened to sign the bottom of. That makes sense, Larry?
Yeah, it makes sense. I just didn't know if we wanted him to sign this incomplete TDS and return it to the listing agent, and the listing agent perceives that to say that we have a complete TDS now.
Oh, I wouldn't. I'm glad we added that. I wouldn't return it to the listing agent.
Okay.
Yeah, the listing agent's obligated to ensure I get a complete TDS. I want it signed simply because I want to document I'm keeping my buyer informed. I've got a TDS. It's got 7 things on it. There's 8 and 9 are a little unclear. We're trying to get answers to 8 and 9, but here are the first 7 that they told us. And I think as a buyer's agent, you should be, keeping your buyer up to speed on what you've got so far.
I have another question in the chat, Walt.
Yes.
Is inspected or no defect noted or no defect noted an acceptable answer on the AVID?
No, I see a couple of people shaking their heads, and it thrills me that you're shaking your head. No, never put no defect noted. I mean, that is, that's slightly better, but not much better than looks good to me. I mean, better inspected is okay. You can write that. A check mark is okay. You want to indicate you looked at the room, but nothing noted should be avoided. No defect noted. That is an absolute no-no, because what you are saying is there's nothing wrong in this room. There could be a lot of things wrong with that room, but you just didn't happen to observe it. So, yeah. Don't put no defect noted. Inspected's okay. A check mark's okay. Better to say brown stain in ceiling, torn carpet, faded paint. Don't put things like minor, small, stuff like that. So, but put down what you see. Good question.
Hey, Walt,
yes.
I think Sharon may have been referencing the portion of the TDS that talks about the agent's inspection disclosure, where we advise our agents, require our agents to check see attached AVID. The second option is agent notes no items for disclosure. I always laugh when I see that. But the last one, I saw this just recently. The third block was checked, and this turns the clock back 15 or 20 years. An agent from another company wrote, buyer is advised to get a professional inspection, period.
Yeah. That's been litigated. Interestingly enough, that does not constitute a visual inspection.
Exactly.
So you can check that box. I don't know if you can check multiple boxes, but you could check that box and still check the box AVID. If you can't, check the box AVID and provide the AVID. An AVID or an agent's visual inspection, sometimes I see, Larry, you and I have seen this, agent writes on the TDS, buyer not a physical inspector and an expert on properties, buyer or seller rather. No, agent, let me back up. Agent is not an expert on condition of property or a physical inspector. Agent recommends buyer get property inspected. Well, courts have said basically, I mean, they say in a little fancier language, but they basically said, well, what we read here is you didn't do your inspection, because this doesn't constitute a blank so you can provide advice to a buyer solely. This constitutes blanks where you can tell the buyer what you saw. And you didn't, all you did is use it to advise the buyer. So, how can you document you actually did the inspection? And that can be problematic. So I wouldn't, writing that's not going to help you at all. So don't write that. All right, folks, thanks for joining me.